Welcome to NIJC's LGBT 101 and Asylum webinar, part of a webinar series for NIJC's pro bono attorneys. And thank you for joining us. My name is Aneesha Gandhi, and I am a supervising attorney with NIJC's LGBT Immigrant Rights Initiative.
And my name is Veronica Portillo-Heap, and I'm the pro bono coordinator of our LGBT project.
NIJC's LGBT project provides legal services to detained and non-detained low-income immigrants who identify as lesbian, gay, bisexual, and transgender, and those who are living with HIV. The majority of our cases, whether they be in-house or with our PBs, are asylum cases.
This presentation is broken into two parts. I'll cover the first part, which is LGBT 101, and Aneesha will cover the second part about understanding the merits of your client's asylum claim. So first, words matter. The topics I'll be discussing might seem basic, but the ways in which we talk to our clients are very important. They directly affect how the client's ability to trust us, even more so than in other cases. The reason for this is because many clients have a claim that involves being bullied, teased, or mocked because they are LGBT and being called derogatory names or anti-gay slurs. And that is why we highly encourage anyone working with an LGBT client to familiarize themselves with this terminology. That way you can be sensitive with the words you use and help your client to feel safe with you, which will likely make the entire process of writing their affidavit and representing them much easier and smoother. So I have this broken down into 3 rules. The first is take cues from your client. So first, use the same vocabulary that your client uses. So as an example, if a client identifies as gay, you wouldn't respond with, how long have you been a homosexual? We generally don't refer to clients as homosexuals because it's a loaded term with a negative history. For many people, it sounds very clinical, and so we discourage its use in your briefs and when addressing your client, particularly if that's not a term that they use to describe themselves. Second, if a client is transgender, ask what name that individual prefers as a first name and use it. Some clients are able to legally change their name and or their gender, so if that is a concern, you can refer them back to NIJC or to the Transformative Justice Law Project, and the link to that organization's website is coming up in the next slide. You should also refer to your client using the pronoun that corresponds to their gender identity. So rather than ask, what are you, you should ask, what is your gender? What is your gender identity? What pronoun should I use? What name would you like me to use? Yes. So next slide. Rule 2, familiarize yourself with appropriate terminology. So the primary terms LGBT, lesbian, gay, bisexual, and transgender are not the only ones. Some of them are umbrella terms, and they each encompass a wide variety of people who live all over the world. These terms change often, so it's recommended that you take some time to make sure that you're referring to your client in a way that makes them feel comfortable. And for some online resources to check out glossaries, USCIS has a training manual on LGBT asylum cases, and also TJLP, which I mentioned before, there is their website, and they also have materials about this. So the primary terms, first, sex refers to biological sex, which includes anatomy, hormones, and chromosomes, and that may be female, male, or intersex. So intersex is a general term that refers to people with reproductive or sexual anatomy that does not fit within typical definitions of male or female. For example, some people are born with ambiguous genitalia, which may share characteristics of what we think of as male and female. So in short, there is a lot of variation amongst biological sex, and intersex refers to people who don't fit into what we generally think of as male or female. Sexual orientation refers to who you're sexually attracted to, who you love romantically, who you desire sexually. So as an example, lesbian, gay, heterosexual, bisexual, and other terms. Gender is distinct from biological sex and refers to someone's internal sex of being a man, woman, or another gender. Gender identity is used most often in relation to transgender people, and that's an umbrella term which refers to people whose gender does not correspond to the sex and gender that they were assigned at birth. So a transgender man is someone who is assigned female at birth but identifies as a man, and a transgender woman is the reverse, so someone who is assigned male at birth but lives as a woman. And then some of the other terms, genderqueer refers to people who do not identify as a woman or a man and identify somewhere on a spectrum between genders of man and woman. Non-binary also refers to people who do not identify as a man or a woman. Some other terms, transsexual fits under the transgender umbrella as well, and it refers to, generally, it refers to people who have had some kind of medical intervention that might be surgery or hormone replacement. People have different feelings about this term, so I wouldn't use it unless the client likes to refer to themselves that way. Cisgender refers to people whose gender does correspond to the sex they were assigned at birth. And then some of the terms below, like transgendered, hermaphrodite, are also terms with negative histories that we also would not refer to our clients as. And then gender expression or gender presentation refers to the physical manifestation of someone's gender identity, so that might be through clothing, hairstyle, etc. So the gender unicorn, this graphic is from Trans Student Educational Resources. It goes over the concepts on the previous slide. So sexual orientation would be sort of encompass both the physically attracted to and emotionally attracted to, and then gender expression as we discussed above. Pronouns, so you're, I'm sure, familiar with she, her, and hers, generally for women, he, him, and his, generally for men, but some people who fit under the trans umbrella prefer gender-neutral terms, most commonly they, them, and their, but there are several other sets of gender-neutral pronouns that are below. Okay, so Rule 3, account for cultural differences. So remember that the perceptions of what an LGBT person is or is not vary by country, by culture. Some clients are not out and proud. They may be more reserved and private about their sexual orientation or their gender identity. Many clients may have experienced conversion therapy. Their family may have wanted to change who they are. And so some clients have a lot of shame around this, and they may even wish now or have wished before that they could change their gender identity or their sexual orientation because they connect it to why they were harmed. So it's important to keep that in mind. And so while the terms we used are sort of most common in the U.S. LGBT community, but there are definitely other terms that are not as common here that are common in other countries. So as an example, travesti is a South American term in Spanish that usually refers to transgender women, but it literally translates to transvestite. So maybe a client might use it, but it isn't really a term you'd use in your brief, for example. And then a lot of Spanish speakers refer to what we would refer to as their sexual orientation, as their sexual preference. So good to keep that in mind as well. And to accommodate these differences, you, again, would use the terms that your client uses when speaking to them, but you would use the terms most commonly used in the U.S. when writing your brief. And then applying these rules, we've talked a lot about terminology. So basically, in summary, important to recognize that you'll be talking about sex and romantic feelings with your clients. That doesn't mean that you're necessarily speaking about specific sex acts, and often that's not necessary, but you will ask about relationships. Some clients haven't had relationships yet, especially our clients who are younger, who are coming from countries that are maybe more anti-gay than others, and that's okay. They may be in relationships while they're here, and there are other ways that their sort of sexual orientation can be proven. And then you should think before asking about, things like sex acts and body parts. Sometimes it's just not necessary. And then just a good practice pointer when you're discussing these things is to be sensitive, but direct and respectful. And then lastly, representing detained LGBT clients. So many detained clients have had some kind of contact with maybe the immigration system or the criminal justice system before. They may have convictions for certain crimes. They may have passed removal orders that may limit their eligibility for asylum or other forms of relief. Communicating with detainees can be very difficult. Generally, you have to request a call at least 24 hours in advance, which can be difficult when you really need to reach them quickly. It can also be difficult or take a long time to exchange mail and documents with them. Many LGBT clients also have more issues and abuse while they're detained than other individuals. It may be difficult to get to speak to them in a private room, which can make it harder for them to get a full story for them and for them to really feel comfortable disclosing important details about their story. A lot of times they feel very depressed and anxious without access to their loved ones. That can be difficult for their mental health, but also difficult for evidence gathering. And then the time frame for representing a detained client is much shorter than it is for non-detained clients, sometimes as short as 4 to 6 weeks, so everything's moving very quickly. And that's the end of my part.
All right, thank you, Veronica, for going over the LGBT 101 section of this webinar. This part of the webinar is meant as an accompaniment to NIJC's pro bono asylum training. So we suggest that you attend or watch the pro bono asylum training before watching this section. Okay. So as a general rule, LGBT asylum cases should be handled in much the same way that you would handle any other asylum case. So you're still trying to prove that your client has a well-founded fear of persecution in his or her or their home country on account of his or her or their sexual orientation, gender identity, and or HIV status. It's important to remember that asylum applications must be timely and the applicant must not be subject to any bars. Both timeliness and bars are covered in the pro bono asylum training, but I will touch briefly on the one-year filing deadline in a bit as it relates to the LGBT asylum cases. And we will have flagged timeliness and bars in case descriptions prior to your taking on an asylum case. However, it is important to keep them in mind always. And if you have any concerns or questions regarding the timeliness of your client's application or bars your client might be subject to, please feel free to reach out to us. So identifying the particular social group. Generally, this is a very complicated part of the law, of the asylum law. However, for LGBT claims, they're pretty well established. For sexual orientation, it's since 1990, being a lesbian or gay man has been recognized as a particular social group. This was affirmed by the 7th Circuit in Moab. And for gender identity, in Hernandez-Montiel, it was framed as, quote, gay men with female sexual identities, end quote. We do not usually use this as our particular social group in gender identity cases. Instead, we suggest using the identity the client most prefers or identifies with. So for example, if you are working with a transgender woman from Mexico, it would be, the particular social group would be transgender women from Mexico or Mexican transgender women. And if you find that your case is not really straightforward, when it comes to a gender identity claim, again, feel free to talk to us and we can discuss best options as to how to frame your particular social group. And as an aside, Chicago judges and the asylum office are overall good about referring to our applicants or sorry, to our clients as by their pronouns and by their preferred names. HIV status, standalone HIV cases are difficult, but as it says, they are recognized as a particular social group in Karuni. However, imputed sexual orientation cases based on HIV recently has been found to be a particular social group in the Seventh Circuit in Velázquez-Venegas, which recognized that while HIV is a virus that infects a wide variety of individuals, there is a widespread association of HIV with members of the LGBT community in Honduras. So based on this perception, the court acknowledged that Mr. Velázquez will be perceived as gay based on his HIV status and therefore be at risk of serious violence in Honduras as a member of many, as is the case, for many LGBT individuals or people with HIV status who are perceived as LGBT in that country. So proving the membership in a social group, of course, most important for any claim is, and any social group you're trying to prove, is credibility. It is important to obtain credible, detailed, and consistent testimony from a client, and this would include written materials and their oral testimonies. Additional evidence can be, third-party affidavits from past or current partners, medical providers, psychologists, family, and friends, and that would go for any one of these PSGs. And for sexual orientation specifically, I would say that you would also want to maybe point to past relationships, or if they have, point to their LGBT activism, meaning maybe participation in gay rights groups or attendance at pride parades, either here or in their country of origin. And just briefly, at this point, for sexual orientation, it is important to remember there is a difference between the conduct and identity, or the sexual orientation and sexual activity. So what I mean is, your client may identify as gay even if he has never had a boyfriend or engaged in sexual activity with another man, but people can have a sexual orientation and still be abstinent, right? So these are still viable cases. In those cases, your challenge is to identify other forms of proof and having others, quote, vouch, and quote, for your client will become extremely important. And then on the other hand, there are a lot of individuals who engage in same-sex sexual conduct, but who are not ready or able to identify as gay, or may never identify that way. And this could also be a viable case as an imputed claim. So it's important that you also remember that you don't allow yourself or the court or government to focus in on sexual activity, but more of the individual's actual sexual orientation. And then specifically with bisexuality claims are among the more difficult of particular social groups. However, they are many times viable claims, and your job is to provide sufficient evidence or detail in your client's affidavit and testimony as to their bisexuality, and to remind a judge or an asylum officer, if necessary, that bisexuality is a sexual orientation and is also a protected group. So if you have a bisexual asylum case, please look to the two cases listed above, Fuller v. Lynch and Walker v. Lynch. In Fuller, Fuller is a bisexual man from Jamaica who was denied withholding and CAT. Majority found that there was no error in the IJ's adverse credibility finding, but a dissent by Posner criticized the IJ, or the immigration judge, for being closed-minded and biased toward claims of bisexuality and for demanding proof that did not exist. And then in Lynch was also a bisexual man from Jamaica. The court granted the petition for review on the ground that the IJ, quote, totally overlooked, unquote, the record evidence that the Jamaican government acquiesces in the torture of gay and bisexual men. Moving on to gender identity, apart from the client's affidavit, and again, the affidavit of family and friends, you will need to show some sort of transition. So a transition is the process of beginning to live in the gender that feels appropriate to that person. So the ways in which to prove transition or to provide evidence of it is medical records. Let's say somebody has a surgical procedure or hormone therapy, or a psychological report would also work, or a letter or affidavit from nurse, social workers, therapists are usually helpful in addition to the client's own testimony. But note that, like Veronica mentioned, medical intervention is not a requirement. Remember, as discussed earlier, that the transgender individuals may or may not want medical intervention or been able to have medical intervention. So moving on to clients living with HIV. Results from HIV tests are sufficient, but keep in mind that if a client's HIV status is also going to be used to make an exception to the 1-year filing deadline, you will likely need to obtain proof of when your client learned of their HIV status. So along with test results, a letter from a doctor or a nurse will also be helpful in proving time period or a date of finding out the HIV status. And then lastly, with the imputed sexual orientation-based claims, but based on HIV status, if a client was HIV positive in their country of origin, their experiences along with country conditions will be central to proving that the perception in their country of origin is that HIV positive individuals and members of the LGBT community are one and the same. So other additional evidence is affidavits from family and friends from their country of origin who may equate the two or know that it is oftentimes equated. And then, of course, if possible, an expert who can link the perceptions of individuals in your client's country around HIV status and sexual orientation. So moving on, just a quick reminder that of the importance of past persecution. So the general rule is just like any other kind of asylum case, establishing the past persecution is critical because it entitles you to the presumption of the future persecution. And NIJC counsels attorneys to always argue some form of past persecution unless there really isn't a viable way given the facts. So that an example of that would be maybe an asylum seeker who came to the United States at the age of 1. There likely is not any past persecution in that individual's case, and then we would not encourage you to make an argument for it. So common forms of persecution in LGBT cases. Significant physical violence was found to be the use of significant physical force against a person's body constitutes persecution. And so keep in mind that physical beatings can be sufficient to rise to the level of persecution. In Dandan v. Ashcraft, which reaffirmed the DUVA v. INS, where the court found that a single beating in which a petitioner was punched had his face bruised and his fingers broken, or his finger broken, constituted past persecution. And unfortunately, we oftentimes see rape and sexual abuse, or that our clients have experienced rape and sexual abuse, and it counts as persecution if it was done on account of somebody's sexual orientation or their gender identity. So many clients are victims of sexual violence, often at a young age, and sometimes at an age that is even before the applicant himself or herself or theirself was aware of their sexual orientation. So these cases can be viable, and there is a chance that the sexual violence is a form of past persecution on account of the individual's perceived sexual orientation. So spend some time exploring why the client thinks he or she was raped or sexually violated. If the rape was never reported to police, yet overall investigation into crimes against LGBT individuals is low, argue that the government could not or would not protect your client from a similar experience in the future. And then also keep in mind that same-sex sexual violence can and many times is a form of persecution on account of someone's sexual orientation and or their gender identity. So even if both parties have or would engage in consensual same-sex sexual conduct or identify as LGBT, that does not matter when it comes to persecution. So The next form of persecution, credible and serious threats, that is also found in Stanojkova, that found that physical threats alone can constitute persecution, and death threats compel a finding of past persecution when they are, quote, of the most immediate and menacing nature, or if the perpetrators attempt to follow through on that threat, end quote. And then forced marriages, they're non-controversial, that forced marriage is a type of persecution. However, keep in mind that it can be difficult to show a distinction between forced and arranged. And then forced psychiatric treatments or attempts to, quote, cure someone of their sexual orientation or gender nonconformity is a form of persecution, even if the person doing it doesn't mean to hurt the person or the individual. Okay. Two harder past persecution arguments, one being the inability to live an open lifestyle. So NIJC has had some success, albeit mixed, applying Stanojkova and Cantoni to the LGBT context. We argue that where an adult client was aware of his sexual orientation in his home country but afraid to express it, his inability to do so is a type of qualifying past persecution, much like the inability to openly practice one's religion. And then the second, pervasive discrimination and extreme harassment, as possibly mentioned before by Veronica when she was talking about bullying and harassment, discrimination alone is not enough to rise to the level of persecution, but it's important to suss out the details with your client as to the discrimination and the amount or the frequency of the harassment by peers or other individuals in their country of origin, and to also keep in mind that if your case involves that lifetime of harassment but no standout instance of persecution, that you make sure to remind the judge to consider the harm in the aggregate, which is sometimes enough. So moving on to government involvement and future risk. If the harm is directly at the hands of the police or your client is from a country that actively prosecutes sexual minorities, then proving government role is really straightforward, right? But clients who endured sexual abuse or other persecution at the hands of family, gang members, or others who are not members of the government, you have to show that the government routinely fails to protect sexual minorities from persecution. These are tough cases, and clients' testimony and the country conditions are key in being able to provide sufficient evidence that the government routinely fails to protect the LGBT community in your client's case. It is important to push back on the idea that your client could or should have gone to authorities after being harmed. It is many times a more dangerous option than just keeping it to themselves or fleeing their country for safety. So a recent decision brings good news in regards to government involvement and what is needed to prove the unwillingness or inability of the government to protect LGBT citizens, and that's Bringas v. Sessions. Bringas is a gay man from Mexico who was sexually abused during his youth because he is gay by his family members. And the court recognized that LGBT people often are persecuted by private actors, and that when such private acts of persecution occur, the victim cannot be expected to report the abuse to the authorities. And the decision is also significant because it explicitly overruled the previous decision, Castro-Martinez v. Holder. In the court criticized Castro-Martinez for creating a different, higher standard for, quote, gay children, end quote, as compared to gay individuals. And because it, quote, erroneously assumed that where the government authorities are able and willing to protect heterosexual children, they will be equally able and willing to protect children who exhibit a different sexual orientation. The court also criticized the decision in Castro-Martinez for failing to, quote, consider the difference between a country's enactment of remedial laws and the eradication of persecutory practices, often long ingrained in the country's culture. So just a couple points on country conditions. As I mentioned before, in LGBT cases, much of the abuse that an individual faces is from private actors. So this means that you have to do more work to show that the culture in your client's country is hostile to LGBT individuals and that the government cannot protect your client from that hostility. So keep in mind that the existence of gay pride parades or gay zones in urban areas do not mean that the country on a whole is safe for LGBT people. And the same is true with legislative reforms. So just because a country has same-sex marriage like Mexico or overturned sodomy, a sodomy law like Chile, does not necessarily speak to the day-to-day experience of the LGBT people in that country. So your job is to point out that incongruity. And sodomy laws, many countries have sodomy laws, and violating these laws can result in strict punishments. However, while the existence of the sodomy law helps you prove that the government does not protect LGBT people, it's not enough, and so you still have to speak to the situation on the ground. And because our project keeps up-to-date annotated indices with an accompanying packet of the country conditions materials for most countries where our clients are from or likely to come from, you will have a significant start to the final index of country conditions. However, it is important to take our index and tailor it to your client, which could mean additional research, deleting irrelevant articles or reports, maybe changing the annotations to be the most compelling to your client, or if possible, getting an expert, especially if your client is from a place like Mexico or Brazil. Along with your index, your brief should have a statement of country conditions that cites to everything in the country conditions section of your index. And I've noticed that judges do prefer the index to be smaller or not 500 pages. And one way to ensure that is to make sure that everything that you have in your country conditions section is also cited in your brief. However, I do want to caution against over-editing or cutting out too much. Just generally, remember that we're here to help and that we can help you support or help support your case and also strategize with you. All right, moving on to establishing Nexus. Of course, easier to establish is persecution, where a client is, for example, coming out of a gay bar and got beaten up, or is arrested or prosecuted under the sodomy laws or the decency laws in their country of origin. But the harder cases are, one, the potential, the childhood sexual abuse, which we've discussed a bit before. And the potential response to this is, we've successfully argued that rape of an effeminate boy, even if the boy doesn't yet identify as gay or never does, or maybe later identifies as trans or gender nonconforming, that rape be construed as occurring on account of his perceived sexual orientation, as long as that characterization fits with the culture. And then a potential response for the second type of harder nexus to establish is, abuser fails to reference client's sexual orientation or gender identity. And, the potential response is that, victims of persecution do not have to show with precision the motives of their persecutor or persecutors. And so as long as there is circumstantial evidence to support the finding, that should be sufficient. And again, we're happy to discuss and strategize with you as to how to frame these arguments. Lastly is the one-year filing deadline. As I mentioned before, there is extensive and more in-depth discussion as to the one-year filing deadline and its exceptions in our pro bono asylum training. But briefly, an individual cannot apply for asylum unless they can demonstrate by clear and convincing evidence that the application has been filed within 1 year after the individual's entry into the U.S. And there are two exceptions laid out in INA 208A2D. And that's one is the changed circumstances which materially affect the applicant's eligibility for asylum, or the second, extraordinary circumstances relating to the delay in filing the application within a year of entering the U.S. So while the two exceptions have been narrowly interpreted, there are a number of circumstances specific or common to LGBT asylum cases that are viable arguments to the one-year filing deadline. So examples of changed circumstances, there's a number on the slide, but anywhere from starting hormones to coming out to being outed, and then extraordinary circumstances a lot of times relate to mental health, which can be depression, PTSD. We see often in our clients isolation and stigma or fear, and many times denial and extreme avoidance of their sexual orientation and gender identity. And so then lastly, I just wanted to mention some practice pointers when it comes to arguing exceptions to the one-year filing deadline. And so one is to create a timeline showing how extraordinary circumstances weave together to explain why an application was filed late and why this is reasonable given the circumstances. And so interview your client or discuss with your client carefully and to discern all the factors that motivated or allowed them to seek legal assistance to file a claim, and to discern every factor that prevented applicant or the client from filing their application. And if applicable, obtain a psychological evaluation. Psychological evaluations can be helpful in explaining how every factor identified as extraordinary would affect the asylum seeker's ability to apply, and or why a particular step taken by asylum seeker represents a fundamental shift in their conception of self, and why when your client was able to file is reasonable given their psychological state. So another practice pointer is identify the changed circumstances that occurred latest in time. So the application must be filed within a reasonable time after that date. So we've interpreted that as 6 months. If it's over 6 months, still ask, can an argument be made for that more time is reasonable given the factors that would constitute extraordinary circumstances or changed circumstances. And then, lastly, is seeking documentation for every factor that shows the changed and extraordinary circumstances. So that could be medical records, name change, psychological treatments, participation in support groups. There's a number of things that can prove each factor that shows the changed or extraordinary circumstances. And then again, just remember that applicants, the affidavit should should cover all facts constituting extraordinary or changed circumstances carefully in a way that the adjudicator, whether that be the judge or an asylum officer, can understand the factual story and the legal theory. And that completes my section of the webinar. Thank you.
Thank you, Aneesha, and thank you again for joining us. For the country conditions materials, which Aneesha mentioned, please feel free to reach out to me. And then if you have questions about strategy or the legal issues, please reach out to Aneesha. And then just a quick plug for the next webinar in our series. It's on April 14th at 11 a.m. about working with a detained immigrant. There's info on our website at immigrantjustice.org/calendar. Thank you.